Hello everybody. Welcome. Welcome to the London School of Economics. Thank you for coming on this glorious and beautiful May Day evening to our gloomy halls. My name is Peter Ramsay. I am an academic in the law school, and the law school, LSE Law School, is hosting this event on a very important judgment for Women Scotland and Scottish ministers. And I just want to say we have tonight 4 experts who are going to give you their view on the judgment, and after that you'll have your opportunity to question them about what they say and any thoughts or concerns you have about the legal position going forward or the judgment itself. So we'll have the talks from the panel first, and then you'll have your opportunity to ask questions. For those of you who are in the overflow room, because we have an overflow room, there are pieces of paper on the desks where you can write a question. If you have a question, give them to Giuseppe or whichever member of staff is there to take them, and they'll bring them to us. I will try as hard as I can to incorporate your questions as much as possible. Can't promise, but if you do have them, we do welcome your contribution, and I'm sorry you couldn't fit in. Normally we have far more people drop out of these events because we don't charge them, but for some reason that's not happened today, so I'm sorry to those of you who didn't get here on time. So I think it's fair to say that our panellists, all 4 of our panellists, are essentially sympathetic to the outcome of the case. We did reach out to lawyers and legal commentators who were not so sympathetic with the idea that we'd have a debate about it. But as you may know, debate on this subject has been notoriously difficult to pull off in real life. Some were willing but couldn't make the date. So just from that point of view, I will be particularly welcoming any questions that express doubts or scepticism or worries about the debate, for those, any of you here who have them. But also I should say that we are hoping to put on a full legal debate with people on both sides in the next month or so. I can't promise it, but we do have a couple of people who are critical of the judgment who seem to be willing to engage, and if we can do that, we will. Watch this space, for those of you who are interested in that. So tonight's event is going to be recorded, and if there are no technical issues, providing there are no technical issues, it will go online on the LSE's Law School's website and on the YouTube channel. So just bear that in mind. If any of you have the Q&A will also be recorded. I think the camera will only be on us, but just know that if providing there's no technical problems, we will make it into a film that will be available publicly. And the last bit of housekeeping is, can you turn off or turn down your mobile phones so as not to interrupt? And I should abide by my own rule. Yes. Okay. We have a truly distinguished panel tonight. We will begin with Naomi Cunningham, a barrister who specialises in discrimination law, you won't be surprised to hear, and has a particular interest in the interaction of the Gender Recognition Act and the Equality Act, in gender reassignment, discrimination, in single-sex exceptions, and in the public sector equality duty. She's well known for having acted in many high-profile cases in this area, and she's also the chair of the human rights charity Sex Matters, who intervened for Women Scotland. So Naomi will go first, followed by Akua Reindorf, KC, a specialist in employment and discrimination and human rights law. She's been a commissioner of the Equality and Human Rights Commission since 2021, and more recently she's been even further elevated to the position of visiting senior fellow at the LSE Law School, no less. And so she's a colleague where she's been focusing on academic freedom questions and freedom of speech questions, and doing sterling work with our students on employment law in our new law clinic. After Akua, it'll be Ben Cooper, a leading silk and employment discrimination and industrial relations, and more particularly in this context, Ben Cooper, Casey I should add, excuse me, he acted for sex matters in their intervention for Women Scotland. And finally, Sarah Vine, Casey, a criminal law specialist who specialises in economic crime and business crime, but also she has a varied portfolio, very serious sexual offences, particularly those involving vulnerable witnesses. And Sarah will wind up by speaking to the criminal law implications of the judgment. So we'll go in that order. Naomi.
Thank you very much.
Oh, can I add one last point? They are all speaking in a personal capacity, just to make that clear.
Thank you very much, Peter. And I gather we have 12 minutes each, so I will do my very best to keep to that, and I'm sure I'll be kept to it if
I should be putting my timer on.
I have essentially 2 points to make. My first point is that the judgment actually changes very little. And my second point is that the judgment changes everything. So I'll try to explain what I mean by that. Until the week before last, the overwhelming consensus among discrimination lawyers, I think it's fair to say, was that sex in the Equality Act meant certificated sex. That is to say, the sex shown on your birth certificate, which will normally be your actual sex, but in a very few cases of people who have gender recognition certificates, will mean the sex, their acquired sex, by virtue of their gender recognition certificate. And the overwhelming consensus was that a GRC changed your sex for the purposes of the Equality Act. I'll just take a moment to explain, for those who don't know the workings of the Equality Act well, why that matters. In the areas where it operates, the Equality Act prohibits discrimination. It prohibits discrimination because of certain defined protected characteristics, things like sex, race, religion or belief, sexual orientation and so on. It doesn't prohibit discrimination across the board. It prohibits discrimination in various particular defined contexts, things like employment, services and public functions, associations and so on. The 2 protected characteristics that we are chiefly interested in here are sex and gender reassignment. Sex I'll come on to, and we're focusing on most of all, but gender reassignment is defined in the Act in these words. A person has the protected characteristic of gender reassignment if the person is proposing to undergo, is undergoing or has undergone a process or part of a process for the purpose of reassigning the person's sex by changing physiological or other attributes of sex. At the same time as prohibiting discrimination in various different contexts, the Equality Act contains an elaborate scheme of exceptions. It's very obvious why those exceptions are necessary. Without them, you couldn't lawfully provide same-sex intimate care, you couldn't keep men out of women's prisons or toilets, you couldn't keep men out of women's changing rooms or rape crisis centres. And I am almost invariably talking about the problem in one particular direction here. I'm talking about the problem of men in women's spaces and much less about the problem of women in men's spaces. Although the legislation is for the most part symmetrical, the world as we know is very much not symmetrical. So it's men in women's spaces that are very much more problematic than women in men's spaces. So to keep things simple, I'm just going to talk about trans-identifying men, but most of what I say will go both ways. So as I've said, the old consensus until 2 weeks ago was that a gender recognition certificate changed the holder's sex for the purposes of the Equality Act. That meant that if you were a man with a gender recognition certificate certifying that you were a woman, and you were excluded from a women-only service, that wasn't exclusion because of your sex, because as far as the law could tell, you were a woman. Your gender recognition certificate had changed your sex. So if you were excluded from a women-only service or space, you were being excluded because you were the wrong kind of woman. You were being excluded because you were a woman not by biology, but by certification, if I could put it that way. In other words, you were being excluded because of your protected characteristic of gender reassignment, not because of your sex. A woman without the protected characteristic of gender reassignment wouldn't have been excluded because it's a service for women, but you were excluded because it's a service for women. But you're both women, as far as the law could tell. This is all still on the old for Women Scotland judgment in the Supreme Court. As far as the law could tell, you were a woman because of your gender recognition certificate. So it must have been your protected characteristic of gender reassignment that was the reason why you were excluded. Now, even under that old understanding, in almost all the situations where sex actually matters, there were specific provisions permitting discrimination because of gender reassignment, which could be used to exclude trans-identifying men with gender recognition certificates from women's services and trans-identifying women from men's services. I subscribed to that old understanding until I think some point in 2022. And it was as a result of many late night ding-dongs with Maya Forstatter here that I finally changed my mind on it. I think most people who'd given the matter serious thought knew that it was unsatisfactory and illogical to have the Equality Act operate in that way with your sex changing for its purposes by virtue of a gender recognition certificate. But I think we all thought that judges would fundamentally look away from the difficulties where they could, and I think they did. And where they absolutely had to grapple with those difficulties, they would find ad hoc workarounds. And true enough, that's pretty much what happened for, depends how you count it, 15 years since the Equality Act was passed, or 20 if you're counting from the Gender Recognition Act. So just to take one of the most striking examples, which was picked out in the judgment of the Supreme Court, if you assume that sex means certificated sex, sex means whatever your birth certificate as modified in some cases by a GRC says, then the protected characteristic of sexual orientation doesn't work at all. That's because nobody on the planet is sexually oriented towards persons of their own sex, plus those of the opposite sex with the certificate, minus those of their own sex without with the certificate. It just makes no sense. Human sexuality is very diverse indeed. I'm willing to go out on a limb and say that I don't believe there's anybody whose orientation depends on the certificate. But despite that, so the protected characteristic of sexual orientation has been broken since the Gender Recognition Act was passed on that old understanding. And yet, there have been plenty of sexual orientation discrimination cases brought to the courts and tribunals and decided, without anyone ever arguing, as far as I'm aware, certainly nobody ever defeating a case on the basis this protected characteristic simply doesn't work anymore. It doesn't mean anything, nobody has it, and therefore you can't bring your claim. That didn't happen. Everyone put the telescope to the blind eye. So even under this old understanding of the Equality Act, you could, in reality, if you got the law right, if you found the route, you could almost always say to any man wanting to use a women-only service, sorry, no, we're allowed to exclude you because you're a man if you haven't got a GRC, and we're allowed to exclude you because of your protected characteristic of gender reassignment if you have got a GRC. We don't actually care whether you've got a certificate or not, because either way the answer is no, even if the route is different. But now the Supreme Court has told us that a GRC doesn't change your sex for the purposes of the Equality Act. That simplifies things. That means that any time it's lawful to exclude men, you can exclude all men because of their sex. And it seems to follow that you must exclude all men because of their sex. Because if you don't, what you're running is not a single-sex space or service at all, it's mixed sex. So you won't be operating under one of the exceptions, you won't be validly operating under one of the exceptions. As I've pointed out elsewhere, it's like peanut-free meals. They're only peanut-free if you leave out the peanuts. It really is as simple as that. So now you can say, in the new world, in the post for Women Scotland, in the Supreme Court world, you can say something simpler to a man who wants to use a women-only service. It goes like this: no. Or to spell that out a little further, it doesn't matter whether you've got a gender recognition certificate or not. You're still a man so far as the Equality Act is concerned, and this is a women-only service, so no. Now those two answers, the complicated answer that wiggled round the possibility that it might be discrimination on grounds of gender reassignment, and the simple answer that just says no, you're a man, both have the same effect. Either way, both the man with a GRC and the man without a GRC can be lawfully excluded. So why do I say it changes everything? That's an explanation for why it doesn't actually change very much. Why do I say it changes everything? I say that because under the old understanding, there was almost always a route, and not absolutely always. There are some cases where it simply didn't work. You couldn't maintain things on a single-sex basis, but mostly, for most of the exceptions, there was a route by which I and many others certainly argued that you could justify excluding men even if they had GRCs. But you did have to wrap a cold towel around your head and study the exceptions in the Equality Act quite closely to do that. There was a route, but it was an unclear and uncertain route. And added to the inherent uncertainty and unclarity in the complexity in the Equality Act, there was a great quantity of misinformation out there in the world, which made the exceptions sound dauntingly difficult to operate. The very worst of that misinformation, I'm afraid, worst and most influential, in the sense most influential, was contained in a statutory code of practice from the Equality and Human Rights Commission, which said any exception to the prohibition of discrimination must be applied as restrictively as possible, and the denial of a service to a transsexual person should only occur in exceptional circumstances. And then it went on to say that decisions must be made on a case-by-case basis. So making that concrete and practical, if you were an employer or a service provider faced with a trans-identifying man who wanted to use the women's changing room or join the women-only swimming session or whatever it was, you had a problem. You didn't know if he had a gender recognition certificate or not. You didn't dare ask. You probably thought you weren't allowed to ask. You'd be in company with the Supreme Court there. That's actually wrong, but lots of people think it. Even if you knew there was nothing to stop you asking, you would be understandably reluctant to ask, because once you've learned that someone's got about someone's gender recognition certificate in an official capacity, if you tell anyone else about it without the right kind of excuse, you're committing a criminal offence. So you very sensibly don't want that information, because it's dangerous to have. So you also thought, under the old consensus, that if this trans-identifying man did have a GRC, it gave him the right to access women-only spaces unless there was some particular case-specific reason why he shouldn't. But you had no idea what a particular case-specific reason might look like. There's no guidance about that. Is it something about him? Is it about how tall he is, how manly he is? Is it about whether he's got convictions for sex offences? But how would you know that? Is it about what medical treatment he's had? Are you supposed to ask him if he's had his genitals remodelled? Really? Or is it about your service users? Are you supposed to ask them whether they've got a history of sexual trauma so as to have particularly strong need for privacy from men? Or quiz them about their philosophical or religious beliefs? All of this is quite bad enough when you're dealing with employees with whom you have an ongoing relationship, but it's even worse if you're trying to make these decisions in relation to casual users of a gym, a nightclub, a pub, a cinema, a swimming pool, whatever. So you've been told that you have to make this case-by-case assessment, but when you think about what that might actually mean and how you might go about it, it bristles with impossible difficulty. And from the point of view of activists on one side of the debate, no doubt that was feature, not bug, because it has had the effect of bringing in self-ID by default. Because it's so difficult to make these decisions, nobody wants to know whether anybody's got a gender recognition certificate, nobody knows how to go about making a case-by-case judgment about which man should be allowed in and which man should be excluded. So service providers and others simply duck the question, back away from it and say, okay, if you say you're a woman, you're a woman. So that's why I say that although not much has changed in what service providers and public authorities are actually allowed to do, everything has changed. Supposing you want to cross a crocodile-infested swamp. Under the old understanding, there was a route across the swamp by way of a series of stepping stones. The stepping stones were slippery and some of them were at funny angles or looked wobbly. Some of them were half submerged under opaque, muddy water where a crocodile could be lurking ready to bite your foot off at the ankle. What's happened now is that the Supreme Court has put up a sturdy stone bridge. The destination is exactly the same, or not quite exactly the same, actually, mostly the same, with a few exceptions. But the risks of attempting this journey have changed beyond recognition. So if you take one point away from what I've said, and I hope I'm just about within my 12 minutes still, it's this. Where it is lawful to run single-sex spaces or services at all, it's okay to have clear, firm rules and no exceptions. You don't have to do case-by-case assessment. Rules can be blanket, lines can be bright. Women only can mean women only. That's what's changed. Thank you.
Akua Reindorf next, who is also going to speak for just 12 minutes.
Yeah, sure. Hi everyone, I'm going to stay sitting down because I prefer it. So I thank you very much, Naomi, for that. You've led in very nicely, laid the groundwork so that I don't have to say half of what I was going to say, and I can talk more about Stonewall's latest missive, which I have double-checked is true on Blue Sky. They have told us, announced to the world, that the judgment of the Supreme Court is not yet the law. Truly, truly. So I'm going to address some of the myths that have grown up and grown like Japanese knotweed over the last fortnight. Well, three of them in particular. I'm going to address the myth that the Supreme Court judgment is unclear, the myth that it is optional, and the myth that it can wait. So those are the three things I'm going to talk about. The first one, that it is unclear. I don't know how many of you have read it. I obviously have. I didn't need to read it twice. I found it an incredibly carefully drafted piece of work, and I think that the Supreme Court did it very much in the knowledge that it was going to be very widely read by non-lawyers, and that is reflected in the judgment. We have heard a lot about clarity in the last fortnight. Politicians initially welcomed the clarity, then they quickly segued into needing more clarity, and then when they got it, it was the wrong kind of clarity, or it was not enough clarity. But the truth is, it's perfectly clear in itself, on its own terms, in all its glorious 88 pages. It is only not clear if you come at it from the wrong angle. The angle, if your angle is that gender self-ID is the status quo ante, then you will struggle to understand it, because you won't be able to get a foothold in where the judgment is coming from and what the basic premise of the argument was before the Supreme Court. Because at the core of the judgment and the case, as argued, is a comparison between the position of trans people who have gender recognition certificates and those who don't, as Naomi has already described for you. A lot of the case was about that, and a key theme in the case was the unworkability that is produced by having two classes of trans people with different rights under the Act. And that's how we end up with the mad definition of sexual orientation that Naomi has outlined for you, which resulted in memorable, immortal even, line in the lesbian intervener's submission that lesbians are not attracted to pieces of paper, which actually made it into the judgment very pleasingly. And that was one outcome of the law as it was understood, that sexual orientation didn't make any sense. And another outcome was that a trans woman, trans-identified male who had a gender recognition certificate was able to bring a sex discrimination claim with a male comparator. So at the core of the Equality Act is a comparison exercise. If you want to bring a discrimination claim, you say, I was treated less favourably than this other person, my comparator, who's the same as me, other than that they don't have my protected characteristic. I was treated less favourably than they were or would have been treated in the exact same circumstances. So a trans-identified male person with a gender recognition certificate would have a male comparator in a sex discrimination claim, and a trans woman without a GRC would have a female comparator. I wouldn't trouble yourselves with getting your heads around it, because it's gone now. But it was from that it followed that a trans woman with a gender recognition certificate would, on the face of it, have had access to a female single-sex service. But a trans woman without a GRC would not have that prima facie right. And the illogicality of that position was compounded, obviously, by the general nervousness about asking people to show their GRC or prove their GRC status, not something that was ever unlawful per se, but heavily discouraged for obvious reasons, clearly unduly intrusive and not practicable in most situations. So in order to understand that this was one of the tensions at the heart of the case, you had to understand that self-ID wasn't the law. You had to understand that there was this very, very large group of trans people, the vast majority, for whom their sex remained under the Act, their biological sex. And that is the premise of the argument about unworkability and absurdity, which was accepted by the Supreme Court. The outcome of the Supreme Court case was that trans people with gender recognition certificates were put into the same position as those without. And it turns out that many, many, many people have simply not understood this basic point. I suppose it's not really surprising, because such incredible efforts have been made over many years to ensure that people don't understand that point. So I think there's quite a lot of people who are genuinely confused and who genuinely did believe that self-ID was the law, because there were various legal fictions that were created, or legal interpretations that were proposed as to why self-ID might be the law, which were utterly hopeless, but nonetheless were disseminated by people who might be thought to be trustworthy. So there's quite a number of people who genuinely believed it, but I think there's quite a lot of deliberate shutting of eyes to it as well. But whatever the reason, the lack of understanding of that is what has, in my view, led to this sort of apocalyptic response that we've seen over the last fortnight. And I think, well, it certainly took me by surprise. I think it's taken quite a number of people by surprise, because the truth is, if you know what the case is about, really the outcome of it should have been merely that, really, for years, trans people without GRCs should have been accommodated in relation to single-sex spaces in a way which was appropriate and lawful, and on the handing down of this judgment, the only change that would have needed to be made was that those 9,000 people who do have gender recognition certificates would have been slotted across into the arrangements that were already in place for those without. But instead we see this huge farce with organisations up and down the country wringing their hands and creating working groups and so on, and people in society worrying that they will have nowhere to go to the toilet. So people are scrambling to get on top of what is the law as it has always been, rather than what the law is now. So I suppose that follows on from Naomi's point that nothing has really changed in some ways. In various ways, nothing has really changed. It is welcome, obviously, that the case and the fact that it was in the Supreme Court and the fact that it was just so clear and so uncompromising in its conclusion has now focused minds on the fact that self-ID is not the law and neither is certificated ID, the law in relation to the Equality Act. But it's slightly depressing, I would say. I would say that companies and businesses and organisations and local authorities and charities and so on have only themselves to blame for being caught on the back foot with it, except that a lot of misinformation, as I've already said, it's been so great that I can only really blame the professionals whose job it is to make sure that accurate law is understood, or the law is accurately understood by the public, and that includes the legal profession, certainly, and the regulators. But there is an element of blame to be attached to the institutions and organisations themselves, because they have, over many years, just outsourced their thinking to external lobby groups, single-issue external lobby groups, naming no names, who have rewarded them for believing whatever they said in a very pernicious sort of loop of money and reward. But I think that's what's at the core of the "it's so complicated, it's not clear" cry that we hear. It's only complicated if you didn't understand the law to begin with, and you continue to refuse to understand that the law has always been pretty clear on self-ID. My next point is about the judgment not being optional. On the day after judgment was handed down, we had an intervention on the radio from a former Supreme Court judge, which has been less than helpful. And the thrust of what he said was that organisations can now have single-sex services and facilities and associations, but they don't have to. They can still operate on a self-ID basis or on a certificated sex basis if that's what they want. This is simply not true. To properly understand why not, you have to have an understanding of the wider statutory framework, which Naomi has very carefully set out for you. But putting it as simply as possible, it is that for services, as follows: a service is either single sex or it's not. It's either single sex or it's mixed sex. To operate a single sex service, you have to show, if you're the service provider, that excluding members of one sex is a proportionate means of achieving a legitimate aim, amongst other things, but that's the key condition that you have to meet. A legitimate aim can be something like the privacy and dignity and safety of women, or something along those lines, or any one of those things. And in order to achieve that, you need to be acting proportionately. So if you have a women's service, this means that you can, if you've decided that excluding men is a proportionate way or a proportionate step to take to keep women safe and ensure their dignity, then you've met the test. But in order to show that it's a proportionate step, one of the things that you have to show is that you are genuinely pursuing the aim. So there has to be a connection between the aim and the proportionate steps that you're taking. If you let some men in, you can't show that you're genuinely seeking to attain the aim, because it totally undermines your aim. And further than that, if you let some men in and you say it's okay for some men to use the service, it can't be, by definition, a proportionate step to take to exclude other men. So you've completely messed up your ability to have a single-sex service in the first place. So that's the rules for services. For associations, it's slightly different, but it results in the same outcome. you can have, under the Act, an association, that's a group of 25 or more people with rules and membership criteria, which is just for people who have a single protected characteristic. So, like, group for older people, children, so on, women, so on. Or if everybody in the group has 2 or more protected characteristics, you can do that as well. But everybody has to have all the protected characteristics in questions. So you can have a lesbian group, that's for women who are same-sex attracted. Or you can have a disabled women's group, or something of that sort. But what you can't have is a group for people with 2 separate, where some people have one protected characteristic and others have a different one. Because then, let's say you have a group for lesbians or women and men who identify as women, trans women, it doesn't satisfy the condition of being a single sex association, a single protected characteristic association for women, because not everybody is a woman. It doesn't satisfy the condition for being a single characteristic association for people who have the protected characteristic of gender reassignment, because not everybody has that protected characteristic. So you can't have that kind of an association. So you can't have a so-called trans-inclusive association. And as Maya says, you can always have 2 associations that join up and do things together. There are ways around it. But fundamentally, what we have started to call assumptions law is wrong, both for services and for associations. And of course, 1 minute? Okay. Of course, if it was possible to have a self-ID service or association, for Women Scotland simply would not have won the case, because this is what the Scottish Government wanted to do. They wanted to have trans-identified males on in a quota for women. If it was possible, the court would have said, yes, fine. So it's hard to see how that theory has developed unless, as I suspect it was done on a very quick, superficial reading of the judgment. It has been extremely damaging. And it's led organisations to believe that there are different possibilities for the way forward and that they can wait until they've had a good think about it. I will just do my final point very quickly. And that has become a trend. It cannot wait. This is my 3rd point. It cannot wait. Stonewall may well be saying it's not the law. I am here to tell you it's the law. With immediate effect. There is welcome news today that the sporting bodies, the national sporting bodies, have all started to get on board. I think that is thanks to some very, very important work being done at the grassroots by a lot of women and some men. I think we need a book called A Lot of Women and Some Men. But the government is also encouraging people to wait for guidance. And I just want to say one quick thing about the guidance. The code of practice that the EHRC is currently revising is for services only. It's not for employment. The employment code of practice, A, doesn't deal with this, B, is 15 years old, and C, is not imminently to be updated. Waiting around for further guidance is a fool's game, and also is totally unnecessary. It is simple. It's men, women, and have a 3rd sex if you want. Have a 3rd space if you want. Finish.
Thank you, Akua. Thank you.
Thank you. I'm going to cover 4 points. First of all, I'm going to, because I think it's so important, reinforce what both Naomi and Akua have said about the clarity and lack of need to await further guidance. Second, I'm going to illustrate that by one fairly technical example, so apologies if you're not a technical lawyer in the room. Thirdly, I want to say something about the fact that this judgment does not remove core protections for trans people, and a lot of the over-the-top reaction seems to me to be precisely that, over the top. And lastly, I want to follow on from that by saying a few things about why the suggestion that I've seen reported that the judgment results in breaches of trans people's human rights that may be capable of being taken to the European Court of Human Rights why that suggestion seems to me to be nonsense. So first of all, not only is this the effect of this judgment the law immediately, but it always has been the law. That's the effect of what the Supreme Court has said, and it does bring clarity. The judgment, it seems to me, is so comprehensively reasoned. They could have taken a shorter route through it. They didn't have to go through laboriously, as they did, every single provision of the Equality Act that touches on this issue and explain why the interpretation of certificated sex that they were rejecting didn't work and why the interpretation that they were supporting did work. But they did that, and that gives everybody a very clear blueprint about how this judgment applies in relation to all of those provisions. You have to just read the Supreme Court, what the Supreme Court says about each of those provisions. And so you don't need to await more guidance. It is the law, and if you're in breach of it, it's no defence to say, well, we're waiting for the Equality and Human Rights Commission to give us further guidance. So the answer is you can find the guidance you need, perhaps with the assistance of some legal advice. I'm always open to instructions. Simply by working logically through what the Supreme Court says, as long as you don't, as Akua says, approach that from the perspective of trying to manipulate it to say what you'd rather it said than what it does actually say. Let me just illustrate the point by reference to, again, a point Akua touched on, which is how you approach comparators in a claim for direct gender reassignment. So that is less favourable treatment because of the protected characteristic of gender reassignment. That's the definition, in summary, of direct discrimination in Section 13 of the Act. And so what you require for that is a comparison, less favourable treatment, with an actual or hypothetical comparator. And Section 23 says that that has to be somebody who is in materially the same circumstances as the person bringing the complaint. What is material depends on the reasons for the treatment other than the protected characteristic that you're concerned with. So you take out, in the case of a claim of direct gender reassignment discrimination, you take out the characteristic of gender reassignment, but all the other circumstances that are relevant to why the treatment in question was meted out have to be applied to those circumstances. Now, previously, we had some unclear and inconsistent authority on this. There's a case called Croft and Royal Mail, which predates the Gender Recognition Act, but postdates the introduction of the protected characteristic of gender reassignment within the previous law of equalities law, the Sex Discrimination Act 1975, as amended. And what the Court of Appeal said, if you can make sense of it in that case, seemed to be that the definition of the protected characteristic of gender reassignment, which speaks of reassigning someone's sex, must mean that for the purposes of the Equality Act in a claim of direct gender reassignment discrimination, somebody's sex changed at some point in that process. And the Court of Appeal was not clear at what point it did change, and so we were left wondering about what are the material circumstances that enable you to decide when the correct comparator changes from being someone of the same biological sex to being someone of the same the sex to which the person aspires. And the reason that's important is because if a trans-identifying man, trans woman, is treated less favourably than women by being excluded from a female service or female facility that that person wishes to access, that will be unlawful if the correct comparator is a woman. But if the correct comparator is a man who is not trans, then that won't be unlawful direct gender reassignment discrimination, subject to any exception. So Croft was very unclear and left scope for argument. There was one other case called Green and Secretary of State for Justice, which was much clearer and said in terms that the comparator would be somebody of the same biological sex. but there was scope for argument because the Court of Appeal, on the face of it, trumps the High Court, which is where Green was decided. The Supreme Court could have not engaged on the issue of a comparator and could have reached the conclusion that it did without thinking about or expressing any view on that particular issue. But as an illustration of the comprehensiveness of the thinking behind this judgment, in paragraph 134, I think that's right. Anyway, one of the paragraphs, they do, it's not, it's 200. They say explicitly in paragraph 200, and this is obviously fundamental to their thinking, that the protected characteristic of gender reassignment and that definition does not result in a change in sex for the purposes of the Equality Act, or therefore for the purposes of a claim of direct gender reassignment discrimination under the Equality Act. They also say, I think it is paragraph...
That was in 200. I just checked.
That was in 200. The correct comparator point is... it is 134. They say in paragraph 134, where sex is material, and there may be some cases where sex is immaterial for the purposes of gender reassignment discrimination. If you just abuse somebody on the office floor for being trans, irrespective of whether they're trans-identifying male or female, sex is immaterial, so your comparator will be a non-trans person of either sex. But where sex is material, then the effect of the Supreme Court's judgment, and they say it in terms in paragraph 134, is that the comparator for a direct gender reassignment discrimination case is somebody of the same biological sex. And that follows also from the definition of what a comparator should be, that they must be in materially the same circumstances. And so the effect of the judgment is to cut through a lot of argument that might otherwise have followed on from this decision about the implications for this particular issue, because you can go to the judgment and you can find the answer, and no lower court or tribunal, it seems to me, is going to depart from the guidance that the Supreme Court has given about those implications. And the effect of that is, in a case for gender reassignment discrimination where sex is material, for example, in the provision of single-sex facilities, single-sex services, it will never be unlawful direct gender reassignment discrimination to treat a trans person, a trans-identifying male, in the same way as all other men, because that would be sex discrimination, and for the reasons Naomi and Akua described, you can rely on the exceptions for sex discrimination in that context, and you don't need to worry about gender reassignment discrimination because that's the effect of the judgment. So that's my second point and my illustration of why all you need to do to get the answers you need is to work systematically through the judgment, and it provides the answers on all the points that you need to address in order to get the guidance. My third point was that the judgment does not remove protections for trans people. The Supreme Court spells this out quite explicitly and quite carefully in one of the final sections of the judgment. But what it does do, of course, is clarify how you can coherently analyse and consider potentially competing interests where sex is relevant and one of the exceptions applies. But outside those very important areas, the protections for trans people against the various forms of discrimination and harassment which the Equality Act protects against are not affected. And they go through this. Take the case of a trans woman and think about all of the different ways in which that person is protected. So a man who identifies as female. If that person is directly discriminated against compared with a non-trans man, or subjected to harassment because of their trans identity, they will be able to claim based on the protected characteristic of gender reassignment, assuming for these purposes they meet that definition. If that person is directly discriminated against compared with a man, or harassed because that person is perceived genuinely to be a woman, then that person can claim on the basis of the well-established principles of perceived discrimination, which the Supreme Court sets out. The treatment is on the ground of, or because of, in the present formulation, sex, and the comparator in those circumstances is a man who's not perceived to be a woman. If a provision, criterion or practice puts trans people at a particular disadvantage because of their trans status compared with non-trans people, and that can't be justified, they will be able to claim indirect discrimination on that basis. But also, if they suffer the same disadvantage of women in circumstances where women are put at a particular disadvantage compared with men because of a provision, criterion or practice that can't be justified, they can also claim on that basis because it's explicitly provided for in section 19A and has always been the law pursuant to European, retained European principles. So in all of those ways, the protections for trans people outside the important but quite narrow areas where sex is material to the treatment in question are not affected. And in fact, I think there is one point that the Supreme Court got wrong, but it's a point that reinforces their overall conclusion on the central issue, and it's in relation to equal pay. There they thought that their judgment did have an effect, because in equal pay, sorry again to get technical, the mechanism by which the provisions act, 2.5 minutes on equal pay, the mechanism
That's Mission Impossible.
the mechanism by which those provisions operate is what's called the equality clause, which is implied into all contracts of employment, and applies with the effect of equalising any less favourable or missing terms of, let's say, a woman compared with a man in circumstances where the man is doing equal work and the other criteria for definitions of discrimination are met. So what you require is an actual comparator of the opposite sex in order for that to bite and work. And the Supreme Court thought that because by saying that sex has a biological meaning, a trans woman, let us say, wouldn't be able to identify a comparator of the opposite sex, i.e. A woman, in order to complain of discrimination if she was discriminated against in relation to pay or contractual terms. The Supreme Court thought that it was thereby removing a protection there that would otherwise have existed, but for various reasons thought that was not decisive in the overall judgment. Again, without going into the technicalities, there is actually a provision in section 71 of the Equality Act which provides that where you don't, the effect of which is where you don't have an actual comparator that you can rely on, you can go back to the ordinary sex discrimination provisions, and so under those provisions, the reasons I've already set out, you can then bring a perceived discrimination case. So if a trans woman is paid less than a man because that person is perceived genuinely to be a woman, that would take that case out of the equal pay provisions back into the ordinary sex discrimination provisions, and contrary to what the Supreme Court thought, that person would be able to bring a claim. And similarly, in relation to indirect discrimination, what are called piggyback claims or male contingent claims are a well-recognised feature of equal pay, so that if there is a group which is predominantly women which is being disadvantaged in terms of pay unlawfully for the purposes of the equality of terms provisions, the women in that group will be able to bring their claim directly and succeed. The men will have to wait to see if the women that succeed, and then will be able to say we're also entitled to the same pay. So again, that protection exists. So that's my third area. Can I quickly do my fourth area, which is the suggestion that therefore the position we're left with infringes and necessarily infringes the human rights of trans people. There seem to be two prongs to this attack from the social media posts I've been shown, even though I'm not on social media, and I've looked at the Good Law Project web page as well, which gives me some idea of where this seems to be coming from. The first is to argue that apparently that there was some breach of Article 6 because there were not sufficient trans voices able to make submissions to the Supreme Court. I won't spend long on that. Respectfully, it's rubbish. The court doesn't generally give permission to individuals to intervene. It can only give permission to organisations who apply, and my understanding is, apart from Amnesty, who did have permission and presented the arguments on behalf of the opposing side, the side that lost, no other organisations purporting to represent the interests of trans people generally applied to intervene. I can't see any circumstances in which there's a breach of Article 6 there. The second and more substantive ground, you want me to finish?
No, just be
it seems to be that the decision runs contrary to European jurisprudence, including in particular the case of Goodwin, which is what prompted the introduction of the Gender Recognition Act, which was a case where it was held to be a contravention of the rights of a post-operative transsexual who had no recognition in law for the gender reassignment that they had undergone and the social role with which they identified. That there are a number of problems with that that argument, but the principal one is simply that Goodwin doesn't deal with the issue that arises in the Supreme Court at all. Goodwin was primarily about things like pension and retirement and the right to marry. There was some reference in the facts to discrimination, that Goodwin believed that discrimination had occurred at work because of their transsexual status, but that's covered by the protected characteristic of gender reassignment. It seems to me that, as I've said a number of times, that the only area where the court's judgment has a significant impact, and it's an important area, is where there are competing rights with sex-based rights. And what the court has done is arrived at a solution which enables organisations to coherently consider and balance those rights, but importantly, on the basis that sex-based rights can only work effectively if it's on the basis of biological sex. And that is not either covered by any of the cases that have been decided in the European Court, and I would be extremely surprised the European Court said that the careful balancing and conclusion that the court has reached is one that necessarily infringes anyone's rights. Of course, you can't rule out that in a particular case an organisation or a government body might get it wrong and might infringe somebody's rights, but that's a different question. It doesn't fundamentally challenge the Supreme Court's judgment.
Thank you, Ben. Of course, it was the man on the panel. I had to speed up. I'm sure our final woman will come in beautifully on time. Sarah Ryan.
Okay, so I don't know how many minutes I've wasted. What I wanted to say. Thank God we've got a man here. About the T-shirt is this. Some may consider it to be in poor taste or triumphalist. You can draw your own conclusions, but I come at this from the angle of being a criminal defence barrister. And what I understand about the experience of victory is that victory, most of the time for me, is when my client has been acquitted. And what the reality is, when my client has been acquitted, is that he or she has had something restored to them. Their liberty, their good name, their property, the bags in which the drugs were found. That's the serious point about how this is not a victory, but this is how we feel. I was going to talk about two topics. I'm going to touch very briefly on one of them. The unifying theme is one of clarity and comprehensibility. And the first one is the proposed legislation to ban conversion practices as they relate to gender identity. The impact that I think that the judgment is going to have is it will end it. That's what I think. I think it will end it because in reality, gender identity is now, I appreciate I come from a self-evident perspective on this, but gender identity is a belief, it is an idea. It's a protected belief, but I am yet to find any definition of it that is able to take it out of the category of belief. If you are going to protect one belief above all others at the risk of criminal sanction, then you, as a state, have to explain to people why you are introducing what is analogous to a blasphemy law. And I have seen a number of attempts to draft this legislation, and every single one of them looks like it had been left in a tumble dryer too long. So just a kind of weeping mass of incomprehensibility. And I'm going to move on to my next subject with this in mind. One of my probably top 420 favourite parts of the judgment is where the court refers to the fact that the law must be accessible and comprehensible to people who don't know about the law, possibly with the assistance of their advisors. Anybody trying to work out what undermining somebody's gender identity amounts to is... yeah, I mean, they're probably going to need some professional help after they've embarked on that exercise. But and that's why I think that the conversion practices bill, is going to go nowhere, if indeed it's even advanced. Comprehensibility and clarity. The reason that I'm here is to talk about sex, the acts. Now that we all have had the law confirmed as to sex, the facts. And there is nowhere, I think, in law where the fact of sex is more important than in the acts of sex and the question of consent. Now I've got to look at my notes. So the law of consent has to be comprehensible to every single person who has the capacity to give or withhold consent. So that means every person, obviously of an age, every person who has both extremely limited intelligence and no formal education whatsoever. That's the bottom line of how comprehensible the law on consent has to be. It has to have a practical and practicable effect. Any valid consent that any valid consent requires that the person giving it has the freedom and the capacity to choose what they are consenting to. So I'm going to talk about deception. There are two kinds of deception in law which will automatically nullify any ostensible consent. They're very, very narrow for obvious reasons. The first is a lie about the nature and purpose of the act, such as pretending it is medical treatment, such as, you may have heard the case of a woman called Ella Janay, who was treated by a therapist. This is a woman who had suffered abuse and quite obviously trauma, and she was treated by a therapist who persuaded her that he had a magic penis, and that the act of him penetrating her with his magic penis would burn away the trauma from her vagina. The Crown Prosecution Service, one of the institutions that we hope to trust, decided that that didn't vitiate her consent. We have a long way to go. I mean, not in my talk. The second form of deception is about identity. I cannot be clear enough about this. When I say identity, I mean impersonating somebody that the victim already knows. So pretending to be her long-lost partner. It is not pretending to be the other sex. It is not pretending to be an animal rights protester when you are in fact an undercover police officer. Morally dubious, though most deception around sex is, there is a very, very, very narrow line around the criminalisation of it. Other deceptions might be capable of negating somebody's consent. And the courts have drawn a very, very close line in respect of that. And that line is extremely proximate to the act itself. To give you some idea of how close the line is, in the case relating to Julian Assange, the court said a deception about whether you're actually using a condom during penetrative intercourse is capable of vitiating consent. In the case of Lawrence, the court said a lie about having had a vasectomy is not close enough to the act, to the sexual act itself. Come talk to me afterwards. I will bore on until you have to leave. In 2013, it became clear that a partner's sex was close enough to the sexual nature of the act, which is the test, that a deception about it could invalidate consent, which makes perfect sense. We don't think about it because it is so absolutely integral to what we do, but I think that what we're facing in the near future means that we are going to have to be far more explicit about this when we talk to children about consent and what consent means. Every single time you engage in any form of sexual activity, you are choosing the sex of your partner. You don't think about it because you just do it. It's completely ordinary part of your sexual engagement. There has been a visible streak in trans rights activism arguing, and I'm going to summarise this, I won't do the argument justice, that where consent is obtained by a successful deception as to sex, and that deception is perpetrated by somebody who identifies as trans, the victim's consent should be treated as valid. And the basis for the argument, and stop me if you've heard this one before, is because she liked it. It's expressed generally as desire-led. The Crown Prosecution Service issues guidance to all prosecutors who are assessing the evidence that relates to an allegation in order to make a decision about whether the suspect should be charged. And you can see it on their website, it's publicly available. They have issued guidance on consent and deception as to sex, and that was updated at the end of last year. It runs to some 10 pages, 80% of which is devoted to gender identity. And it leaves the reader with the impression that a person's stated gender identity is a relevant and important factor in whether that person should be held liable for a deception as to their sex, which is a logical and a legal nonsense. If the verifiable fact of a man having had a vasectomy is not sufficiently proximate to the sexual nature of the act, then the metaphysical identification of oneself as being the other sex, I hope you would agree, doesn't come close. So the CPS are going to need to amend this guidance, I think, and revise it so that it reflects the law as it is, because the law as it is founded on the pretty much uncontroversial principle that the protection of a person's sexual autonomy and bodily integrity is greater than the protection afforded to a person's desire to be perceived and treated as the sex that they are not. The reason that I think that this is so important is successful deceptions as to sex are relatively uncommon, and they seem generally to be achieved by women and girls because, put coarsely, women will tend to be more successful at passing as male than vice versa. However, it won't be long before we see a cohort of people who have been given puberty blockers and then cross-sex hormones becoming sexually active. And of course, there is a very large subgroup of those young people who are same-sex attracted. And that has kind of become the pathway into puberty blockers and cross-sex hormones. We don't yet know what that looks like in practice. We don't yet know how difficult it is going to be to tell the sex of those people. So I think that more people are going to be capable of successful deception. So it is vital that both law and policy take hold of the bright line that has been confirmed by the judgment and make sure that it is held.
Can you wind up, Sarah? Sorry.
Good, because I just got to the last line. And it's just this. The definition of consent for the purposes of criminal law is often used as a touchstone in other areas. And most notably where physical contact is involved. So I anticipate the clarification of the law as a bright line is going to be felt in multiple areas: policing, medicine, health and social care, the area of the family perhaps. With that, I didn't prepare anything in my talk about toilets. Having spent some years being accused of constantly going on about toilets and now being asked repeatedly about toilets. But I'm happy to answer any questions.
Okay. There are a lot of women and some men in the room. I'd like to hear from as many of you as possible, but raise your hand if you've got a question. When I take you, could you use the microphone in front of you? There's a little red button. If you could press that when you speak, that will be helpful. Feel free to tell us your name.
Apparently the front row mics don't work.
Okay. Feel free to tell us your name, but you don't have to. And please ask a question. I appreciate some of you may want to preface your question, but I will be strict in keeping any preparatory comments short. So at the back, because you were quickest off the mark, does your mic work?
I have no idea. Does it work?
Yes.
Sorry. I'm Daniela. I have a quick question. It should be really easy for all of you. The latest gotcha on Twitter seems to be, is there a law that actually prevents men using women's toilets? Is there a paragraph, a law, anything concrete that makes it illegal for men to use women's toilets.
Okay, I'm going to take a couple of questions and let the panel respond to to those. So another one at the back.
Great, thank you. My question is, we're still seeing reams of misinformation about the law, latest example being Stonewall, as Akua mentioned. What's the job of the legal profession in combating that misinformation, particularly given that some of it is coming from within your own ranks?
Thank you. And then lastly in this round,
I'll
Helen at
just
the
say
front.
really loudly, the thing that I've noticed that seems to have changed most since in the 2 weeks is I've realised that there's no route to ever in the future changing sex in effect. Like before this, there was the Croft and the Green thing of like at some point in the future you would count as the member of the opposite sex. And this seems to me to undercut the whole basis of gender medicine. Am I going too far there?
Okay, we'll take quick answers to those three questions.
Yeah,
So
I'm
who
not
wants to
answering
take
that
which one?
I can do the toilets one.
Sarah, the toilet.
This year's criminal practitioner, toilet specialist. I'm not a toilet specialist. You can. So I don't think it's a great idea to go in hard with this one, because the whole point about policing single-sex spaces it's done by way of kind of social contract overwhelmingly, recognition and trust, if you like. But I don't know yet if it's just noise that's being heard on social media about, we must all continue to hold the line and we must keep, going into the women's bathrooms, we must keep doing this for freedom. And, who knows how much of that is actually going to happen. But, there are so many ways to talk to people who are doing it, to say, look, it's not okay. It is a single-sex loo. It's not reasonable. We do have a third space, hopefully. But if it is sustained, deliberate, then there are ways to deal with it in the criminal law. If it's targeted at a particular person or group of people, it can be criminal harassment. It can be, depending on the setting, it can be a public nuisance, it can be a public order offence. So, irritatingly, the answer is the one you always get from lawyers, which is, it depends. So, yeah, so don't go in hard, just going, this is what you're doing.
Okay, thank you. Akua.
Thanks. Actually, just on that question first, I mean, your principal remedy is going to be against the employer or service provider who has failed to enforce a single-sex rule under discrimination law. So, yeah, accosting individual people, probably not best advised. Now, on the question of the legal profession, thank you, Sonia. Yes, the answer as to what the legal profession needs to do is two things. One, step up, but two, take your time. And three, in the meantime, leave it to the experts, because there are some of us, and there are not many of us, but there are some of us who have made it our business to understand this area of law. And it is actually, although the answers are simple, it is actually a complex area of law. Understanding how Schedule 3 of the Equality Act works took me a lot of head scratching. And I've seen a lot of lawyers coming out on LinkedIn, which, I mean, I wanted to poke my eyes out up to 2 hours on LinkedIn, but giving just the wildest advice that I have really ever seen. And it's very, very depressing, because it will just take us back to square one if people carry on like this. And, rushing out guidance documents to send around to all their clients, because now people can, and I hate to say this about lawyers, but they can smell the money. And, having avoided this wouldn't touch it with a barge pole for years and left it to a few of us to deal with, are now scrambling in an unseemly manner to get on top of this area of law, and they're not on top of it, some of them. Obviously, some are very thoughtful and careful, but, please come and join us. You're all welcome, lawyers. But please make sure you understand it before you give advice to clients, because there are serious, obviously serious problems if you give bad advice to people.
Thank you, Akua. And Naomi,
Thank you.
Helen's
Yes.
question.
I'll have a go at Helen's question, which was, does this undercut the whole idea of medical transition? And I think it goes further, if anything. It undercuts the whole idea of social transition too, and maybe that's prior, because what it says is that even with a GRC, even if you go, it certainly wipes out the whole idea of self-identifying into being able to force other people to treat you in circumstances where it matters, as if you were the opposite sex, by letting you into spaces and services and so on for the opposite sex. So that's gone. You can't self-ID into the opposite sex spaces and services. You can't even, by going through the process to get a gender recognition certificate, force other people to treat you in those respects as if you were the opposite sex. With that, what is the point of medical transition? You can fool you unless, to the extent that you can fool people, you can invade spaces meant for the opposite sex in stealth and get away with it, and that may be the only remaining content. And that, you know, there may be ways of preventing you from doing that if you can be detected, but no doubt some people will continue to do that in stealth. But this takes me back to one of the most satisfactory to me aspects of the Supreme Court's judgment, which is to bury with a stake through its heart a notion that comes from the House of Lords in one of the pre-Gender Recognition Act cases, A and Chief Constable of West Yorkshire Police. This idea that you ought to be entitled to be treated, you ought to be entitled to have other people pretend that you're the opposite sex if you are, quote, visually and for all practical purposes indistinguishable from somebody of the opposite sex. And words fail me. What did their lordships think were the practical purposes for which sex might matter? And how did they possibly think that for all practical purposes, anyone could actually change sex? So it's nice to see that dead and buried, but yes, the short answer, I think, is yes, it undercuts the whole project. It makes it impossible to see how it can be defended as ethical, to tell especially young children and young people, to tell any confused, distressed people who wish that they were not the sex that they are, we can change your sex, when the law won't recognise that. The law won't make other people play along. It's gone.
Thank you. More questions? Let's, for the sake of, should we call it gender balance, take a fellow at the back.
Oh, it's on now. Can I ask maybe just a quick two-part question? Firstly, does the panel think being treated as your sex could amount to unlawful gender reassignment discrimination in any circumstances? And secondly, if it does that mean that there is now some lawful entitlement to, for example, a third space? Is there now a requirement on providers of spaces to provide third spaces? Or is this just something that's prudent and practical that would be nice to have, but there isn't necessarily a legal obligation?
Okay, thank you. I'll take two more.
Hi, my name's Louise Irvin. I've heard some employers saying, oh well, what we'll do now is just make all the toilets, changing rooms and everything mixed sex. And now, although I know the employment regulations say that we should provide separate sex provision, it would mean that actual individual employees would have to take individual discrimination cases, and that's very hard for lots of people to do. So what do you say to those employers who are thinking that's their way around the problem, which is just to make everything sex neutral, or whatever, multiple sex?
And right in the middle there, at the back.
I'm sorry to ask another. Can you hear me?
Yeah, no, I don't think it's working actually.
Okay.
Try the next one. Okay.
I'm sorry to ask another question about toilets, but there's been a lot of suggestions about using disabled toilets. Is there any legal basis on which to challenge services or employers who suggest this as an option? So, as someone that has a radar key, when you know, like, there's lots of us with hidden disabilities or hidden health conditions, and I think it's totally inappropriate. So I'm just curious if there's a legal basis on which to challenge that.
Sarah, they're all for you.
The first one's for Ben.
None of them.
The first one's for Ben.
Yes, I know. Do you want to take the first one?
Sure, yeah. I'll have a go at the first two together, focusing on employers because it's a bit different, probably same answer in the end, but a bit different service providers. So for employers, the 1992 Workplace Health, Safety and Welfare Regulations require separate sex provision, it seems to me overwhelmingly likely that the Supreme Court's reasoning that led it to the conclusion that biological sex is the meaning in the Equality Act would lead to the same conclusion in respect to those regulations. And so the starting point, and sorry, I should just say, so what they require is separate sex provision unless you can accommodate everyone with sufficient facilities that are in separate lockable rooms, and the effect, on my reading at any rate, is that the wash facilities, the basins, also have to be in those separate lockable rooms. So that's the starting point, and obviously, and so then within the framework of the Equality Act, it seems to me that the way a case gets off the ground is that if the provision your employer provides for you means that the toilet facilities are particularly unsuitable for women or for trans people, because if you're trans identifying, you don't feel able to use the single sex facilities that correspond to your biological sex, which is the starting point, then that may be indirectly discriminatory in respect of that characteristic, unless the provision is justified. So take first of all the trans identifying male, trans woman who wishes to use the female toilets, doesn't feel comfortable using the male toilets, and may well be able to say there's a particular disadvantage to me and people who share my characteristic because you're not providing suitable toilets for us. The question for the employer then is the provision that you've got a proportionate means of achieving a legitimate aim? And it's obviously a proportionate means of a legitimate aim to comply with the regulations that I mentioned, but only if, it seems to me, you can't reasonably also make some other suitable provision. So the answer, I think, to Michael's question is yes, potentially there is a case there, but it will depend on all the circumstances, and in particular whether the size of the employer, the size of the nature of the premises, what could or couldn't practically be done, how much it would cost, how difficult it would be, all of those questions. Could you reasonably provide some further and additional suitable provision? So that's the answer to that. And then, sorry, I've forgotten the questions.
Going gender neutral, just going everything gender
Going everything. So there, and perhaps I should hand over to a woman who knows the particular concerns of women in that regard. But from things I've read and seen, it seems to me that there are likely to be features of any completely gender-neutral provision, set perhaps in the most swanky and capacious type of accommodation, that women would be able to argue put women at a particular disadvantage because of they are less safe, or they are less private, or they are less dignified. But again, it will depend on the particular circumstances.
But also, as Ben said, in an employment situation, in a workplace, it's mandatory to have them separate, or in single lockable rooms, which are floor-to-ceiling walls open onto a free-flow area. You can't. It's not cubicles. But in a service, yeah, I think, indirect discrimination is the way to go with that. And I think it's, and in fact, there is an argument. I'm looking at Michael, that it's direct discrimination, but I'm not going to trouble you with that. You'll have to talk to Michael about it. But yeah, it's complicated. What was the third question?
Disabled toilet.
Oh, the accessible toilet. Yeah, I mean, the EHRC guidance is, I believe, says not to assign the accessible toilet for use by trans people. I mean, I think that the situation is perhaps a little bit more nuanced than that. I think that in a workplace situation, if you are in a workplace where there is one person who needs to use the accessible facility and one trans person, I think, in that circumstance, all of these things are going to be fact sensitive as to how an employer or a service provider is going to manage their premises. But I think in a situation like that where it's manageable for people to share, and in fact Croft and Royal Mail, that old case that Ben talked about, I was a pupil barrister at that time when that case was being fought, and my pupil supervisor was Diana Rose, and I had to go to the Royal Mail sorting office in Leicester and take pictures of the accessible toilet that they were making the trans-identifying employee use. And that case, all the way up to the Court of Appeal, it was said it was fine for that person to use the accessible toilet. So I think it's, but in a public situation, I don't think it's appropriate for the accessible toilet to be used. But each of these things is going to have to be worked out on a case-by-case basis, depending on the premises. And especially if we're saying, look, suddenly there's this law. Well, I mean, despite what I've said about it, it's always been the law. But people are suddenly waking up to the fact that this is the law. If they have to make some interim arrangement while they're sorting things out, then I think it's, understandable, reasonably.
Great, more questions. Ideally non-toilet questions for now. We can come back to more if there are. Go at the back with the glasses. You've sort of pressed the button. Just talking to the mic. Try talking.
I don't think the light's going on.
There you go.
My name is John, that's all I'll say. It's been great to hear four barristers, experienced barristers, talking about the Supreme Court judgment, which I thought was brilliant. My worry is that the government will create a new Act of Parliament which says the Supreme Court was wrong. Would you care to comment on that, please?
Great. Very energetic hand raised at the back.
Hello, I hope this works. Yes, good. I am one of the victims. I'm a trans widow. There are others like us, very few, and there's a much bigger cohort of young people who are now coming into their late 20s, 30s. When are we going to get some compensation for the appalling mistreatments, misjudgments, derelictions of duty by all authorities and medical people? Please.
Thank you. And third, yes, in the second row there.
Hi. This is in relation to an article, a legal critique by Crash Wigley. What Wigley said was that the human rights consequences of biological sex was overlooked by the Supreme Court, and I was hoping to get your perspective on that, as well as a statement that Wigley also said about how the Supreme Court was presented with a strong argument grounded in case law of the European Court of Human Rights that a trans-exclusionary interpretation of sex would breach Article 8 of rights of trans people. What would your take on that be?
So we have the Crash Wrigley argument about amnesty, compensation, and what about Parliament just overruling the Supreme Court with statute?
Do you want to do Parliament?
Shall I have a go at the last?
Mm-hmm.
I mean, really, this is a question about political crystal ball gazing more than law, so it's a little bit off my patch. But my guess is that no government is going to want to open this can of worms anytime soon. The current government may not be wholly enthusiastic, or may not be unanimously by any means enthusiastic about the result, but I think having it taken off their desk and dealt with, and they hope put to bed, is probably much better politically than having to have another great big fight. And they might be looking nervously at Scotland and what happened to Nicola Sturgeon last time she opened up these issues. So my guess is that that's not a worry. I don't think we're going to see an Act of Parliament overturning this. Could happen, but...
Yeah. On that question, I completely agree with Naomi. I mean, already what we're seeing from the government is this is lovely, great, lovely, clear, EHRCU deal with it. That's what they are doing, and pretending that, hoping that if they sit still and stay quiet, it will pass by. I can't see any prospect of them bringing this debate into the House of Commons at all. So I wouldn't worry too much about that. On the trans widows issue, I'm sorry, but I just don't have the knowledge and expertise to talk about that. I'm sorry. And what was the other question?
The Article 8. But
oh, the Article 8, Ben can deal with Article 8.
Okay, so as I said, I think there is no infringement of Article 8, and that's fairly clear because the Supreme Court didn't overlook the implications of a biological sex reading for trans people. They carefully analysed what that effect was, and they concluded that on all the central protections of the Act, it has no effect. The only area where it has that effect is where sex is relevant, and by definition within the terms of the Act, that is limited to, essentially to areas where there are identifiable interests of women or men as biological groups which ought to be protected or enhanced or addressed. And or there are particular needs of women or men as biological groups. And so all the Supreme Court has said is that in those circumstances, those rights and interests of those biological groups ought to be analysed in those terms, and separately, the rights and interests of trans-identifying people can be addressed through the positive action provisions, for example, which can apply in respect of gender reassignment. And I suppose the only very narrow area where the judgment doesn't leave it open for an individual employer to balance is that if you think, for good reasons, single-sex services or facilities are appropriate and necessary and justified, you don't, on the basis of the way the judgment will apply, you don't have the choice of doing that on some sort of fudged basis, allowing some men who identify as women into women's spaces. But again, it seems to me that the simple answer to that is the one that runs all through the Supreme Court judgment, which is that there's no other workable way of addressing those needs on a biological, other than on a biological sex basis, because that is the basis on which the need arises.
Naomi.
Thank you. I just wanted to come back a little more on the question from the lady who identified herself as a trans widow, because I think it's worth acknowledging very squarely that some of the wrongs that have come out of this mass delusion, I'm going to call it, are capable of legal remedies, sometimes partial legal remedies, sometimes quite complete legal remedies. But probably most of the worst wrongs and harms that have come out of this won't be amenable to legal remedies at all. So I'm afraid the answer to your question and the answer to a similar question raised by the parents who've lost their children to this cult, the parents whose children have gone no contact with them, the children who've lost a parent who's a father or maybe occasionally a mother who's decided that they're no longer that parent, they're the opposite sex parent. The young people who've lost body parts and any hope of a normal sexual functioning adult life. Those wrongs will never be fully righted, and most of that the law simply can't touch. And I think it's very grim and very, very gloomy, but that's the truth. There will be no proper compensation.
Yeah, I just wanted to come back on the Article 8 arguments made by Crash Wigley, who I believe used to be Lord Lloyd Jones's judicial assistant last year, not this year. So a couple of things worth bearing in mind on that alleged or purported Article 8 challenge. One, the person I believe who's thinking of making it, is it Vic McLeod? Yeah. It was not a party to the case. Two, McLeod lives in Ireland, so I struggle to understand how McLeod is a victim or establishes standing in the case. And three, the Article 8 point, or in numerous human rights points, I can't remember the ins and outs, were made by Amnesty. Their submissions were heavily Article 8 human rights based. And there's just no reason to think that the Supreme Court overlooked those arguments, notwithstanding the fuss that is being made about the idea that they may not have appreciated those arguments. I mean, you can't just go to the European Court of Human Rights as some random person from a different country and say, I don't agree with what the Supreme Court thought in this case, even though everybody made all the arguments that I'm now going to make to you. It's just, I mean, I don't know. I mean,
but that doesn't rule out someone from within the UK trying to make the same argument.
But really,
I'm interested. Is on the Crash Wrigley argument? Is your view then that, I mean, as I understood it, and my understanding is very limited, so just correct me if I'm wrong. What Amnesty was suggesting was that the biological definition took a trans person back to Goodwin's position of being in the intermediate zone that is not quite one gender or the other. And your position is no, that's just wrong. It doesn't get off the ground with respect to the decision made. Yeah.
That's wrong. It doesn't get off the ground, but it does. It's also not on the issues of pension and national insurance contributions and right to marry that were at the heart of Goodwin. So those were the issues that led to that comment. And I don't think you can read that phrase then more broadly just to apply to any area where there's a potential conflict of rights, which is wholly different.
Exactly, and we brought in the Gender Recognition Act in response to Goodwin. I mean, the argument now is, I suppose, they've stripped it of meaning because it doesn't cover discrimination, but it does. I mean, it doesn't, but we have the protected characteristic of gender reassignment in the Act as well. And I mean, one thing to be thankful for in relation to the GRA is that demonstrated by the Supreme Court judgment. If we hadn't had the GRA, we may well in this country have gone down the route, back in the Goodwin days, of merging gender reassignment and sex in the Equality Act or in the equality legislation, as they've done in, I think, Australia and many other countries, or several other countries. And so that the way that the rights would work would be that if you were trans, basically you got immediately protection from sex discrimination in your acquired gender, rather than there being this separate characteristic of gender reassignment within the equality legislation. And it would be very, very difficult to unpick it at this stage. So the Gender Recognition Act may have actually been quite helpful in this context. Oh, and, you know, and the fact is that in the Scottish debates over the GRR, it was being proposed that it was just admin. The Gender Recognition Act was just for admin. It was for marrying and dying in dignity and being buried in dignity. You know, and it is now. fine.
Okay, I'll take a last round of
Agree with
questions,
that.
particularly interested in any raising doubtful points about the judgment, but is there
Don't think you're
anyone
gonna
who
get
really wants to...
them.
Okay, in the middle there. Does the red light come on? Hang on, just... Oh, front row doesn't work. Can we give you a mic?
Speak very loudly.
No, well, I'd like to... Can you speak to the mic, because then we can do the recording. Thanks, Rebecca.
Hello, my name's Hannah. I'm an undergrad at LSE. And I welcome the result of this judgment, but I've had a lot of questions from my friends and my peers who really, really very strongly do not. So I'd like to ask you a question that they've been asking me, which is, what do you say to the argument that this ruling has tangible, real-life negative impacts on the lives of trans people? Maybe not in this very specific legal sense in the Equality Act, but in the sense that this ruling socially, culturally can be argued to negatively impact the lives of trans people.
Thank you. And gentleman there.
Keep it on, hold it down.
Shara Ali, Green Party, on and off. I just wanted to reflect on one of the points being made in the debate was around...
Make it a quick reflection.
Absolutely.
If you would,
Okay, well, bottom line is, what are we going to do about pronouns? And I think we've got a great opportunity now to reclaim, just as we've reclaimed the word woman, we don't have to qualify it with cis and all that kind of nonsense. One of the ways, the kind of pernicious anchors that are being used to try and manipulate us into validating gender identity is this use of gender identity-based pronouns. But can't we now revert to sex-based pronouns without the risk or compulsion that we're going to be accused of discrimination because we're misgendering? We're just using sex-based pronouns. Thank you very much.
And well, on that point, we have a question from the patient overflow room, which is speaking specifically of schools, asking about schools, and in this case a primary school. Can a school compel school staff and, most importantly, other children to refer to a boy as she following the judgment? And how would you advise staff to proceed in the light of the judgment? So that seems to be a related question. And then just lastly, because you've been waving at me, the woman right at the back there, right from the beginning. Put your mic on if you could. Can you put your mic on?
So my question is about myths. Akua, you were talking about myths. One of the myths which I think that the media have still captured, and it has been scrambling around for a myth to latch onto, and the myth that it seems to have latched onto is that the judges said that trans women are women except for the Equality Act. And this has quite a big impact when you're trying to stop or end media capture, because when you go to edit, they've been saying that they will wait for the Supreme Court judgment, but they will say, well, actually, in all other areas apart from the Equality Act, self-ID still obtains. So we will not be, and of course media capture is the petri dish of all this misinformation that's been swirling around for the past 15 years.
So can we take that question
Yeah,
first,
I'll do
and
that.
then the pronouns and
Yeah.
names questions, and come to Hannah's question
I'll
last?
be very quick and then I'll pass to my fellow people. The Supreme Court judgment was only about the Equality Act, but the Gender Recognition Act itself has exclusions in it where trans women are not women. For instance, if you're a hereditary peer, or if you're a parent, and also the Supreme Court judgment went as far as was possible for it to go in giving a steer on how to interpret other legislation, and it gave a very, very low threshold for interpreting other legislation to not mean that trans women are women, if essentially the legislation in question is dealing with something where sex matters, then it's fundamentally, I mean, you know, there is a legal test, but it's not much higher than that. Then trans women are not women for the purposes of that legislation. On schools, strictly speaking, the judgment doesn't even touch schools because no child has a GRC. But what it has done is it's opened up the conversation massively. So this is a good opportunity, I think, for schools. On pronouns, again, it's not really an issue arising from this judgment, but I have noticed a very great deal more openness to using sex-based language and willingness to do so in society at large. And I forget the first question.
Hang on, come on. So your practical advice with respect for a school teacher, that was specific, would be what?
In relation to what?
Well, into whether they are required or
required to use
pronoun, or to what if other children don't want to use the pronoun preferred by the boy in this case, or a girl.
I would hesitate to advise on that at this point, but I think now is the time to have those conversations within your staff groups with your head teacher. Look at Sex Matters website is usually what I say to people when I don't know the answer.
Unless there's any more on that, it's a specific answer then to Hannah's question about the negative impacts and what you would say to that question, because that's very alive in a place like this.
Yes, absolutely.
My answer to that, it's often said by the pious that rights aren't pie, but actually rights are pie to a very large extent. When there's been a sacrifice of the rights of one group to the claims of another, and there's a correction of that, then the people who had been benefited by that drift will have to give way. So it's no doubt the case that lots of trans people will feel that their current position is quite severely negatively impacted by the judgment, and that's inevitable because, I mean, for example, single-sex spaces will be able to say no to trans-identifying men with complete confidence now, where they couldn't before and where almost none of them dared to. So trans-identifying men had it all their own way, in a way that simply set the value of women's rights at zero, and that needed to be corrected, and that's what we've seen. So I'm afraid we just have to face that when women's rights in particular, but when the rights of other people not to be made to pretend are reasserted, then those people who wanted everyone else made to pretend that they've changed sex, those people won't be happy about that. Can't be helped, I'm afraid.
For the purposes of law, certainly for the purposes of criminal law, if the harm to which your friends refer can be clearly identified, and I'm really not being facetious here, because what we're dealing with is a debate, a discussion where terms have not been used in common. So terms like harm and violence and even genocide are being, I'm really not being facetious, are being used to mean completely different things from what I regard as the common meaning. So I think it's important that any harms that are causing concern can be clearly identified. And if they can be clearly identified, then a remedy can be sought. And there is absolutely no indication in this judgment or amongst lawyers that protection from actual harm is something that is ever going to be taken away from trans-identifying people.
I'd just like to say one thing to you, Hannah, as well. Thank you for your question. Unfortunately, young people and trans people have been lied to over many years about what their rights are. And it's like Naomi said, I just can't say it in a more diplomatic way than that. But they've been lied to, and there has to be a period of correction because other people have rights.
Okay, thanks very much. We're out of time. Before we bring the event to a close by thanking our panel for giving up their time and a good deal of their lives to this question, I'd just like to alert you to two things. First, if you wish to continue the conversation immediately afterwards, the George IV pub is open and accepting guests. It's immediately opposite the entrance to the building. You might have seen it, and I think the speakers will be available for at least one drink afterwards to continue the conversation. And then second, If you would just stay in your seats just for a minute or two after we close the business of the meeting, there's just a couple of other things that we'd like to do, that some people present would like to do before we wrap up. So would you join me in thanking our panel?